attorney to you. Mr. Johnson is a very, very good attorney. And it's not going to cost you nothing. All right, go ahead.
I understand that, Your Honor. My thing is I wanted an attorney because I wasn't given one. You said that you was going to appoint me.
And you got one now.
What you're about to witness is one of the most frustrating exchanges I've ever seen in a courtroom. Jerome Gibson stands accused of distributing marijuana without a license, a charge that could land him 93 days in jail and a $500 fine. But instead of accepting help from Vassal Johnson, one of Michigan's top-rated attorneys provided to him completely free, Gibson does something absolutely reckless. He rejects the lawyer, argues with the judge, and insists he knows better than everyone in that courtroom. Judge Perkins tries everything, reasoning, explaining, even raising his voice, but Gibson refuses to listen. This isn't just courtroom drama. This is a psychological breakdown of pride, paranoia, and the dangerous belief that you can outsmart a system designed by legal experts. Let's break down exactly what went wrong.
Let me stop you right now. I can't hear anything about the situation or the facts of the case until we get an officer in here so he can tell his side. That's the purposes of a trial. But you knew you had this case out here.
Right.
And when the last time we were here, we said we would appoint an attorney to you. Mr. Johnson is a very, very good attorney. And it's not going to cost you nothing. All right, go ahead.
I understand that, Your Honor. My thing is I wanted an attorney because I wasn't given one. You said that you was going to appoint me.
And you got one now.
Okay, but I don't understand. He telling me this is a very serious misdemeanor matter, and I ain't even been arrested for this case. I haven't been arrested or anything.
What does that mean?
I want to be represented, but I mean, if you're going to give me somebody, I would prefer somebody who tell me what's going on, man. I don't understand what's going on. I don't.
I can tell you what's going on.
I appreciate it.
It says
he gave me a ticket I can't even read, John. It's unreadable. I don't know.
I can't read it either.
Okay, that's what I'm trying to tell you. I don't want to
send that to Mr. Send that to Mr. Johnson. Send that to Mr. Johnson. All right. It said something about remuneration, selling marijuana. I honestly can't read it either.
Judge, on the ROA, is it a trial or pre-trial? I can't make it. Looks like both.
It's a pre-trial. It's a pre-trial.
Oh.
The last time we were here, I asked Mr. Gibson, does he want us to appoint him an attorney? I say that, Mr. Gibson, this job that I have is really the same lines every single solitary day. It's just some lines change. In this thing, I tell you, do you want us to appoint an attorney? You obviously said yes. And I told you, okay, I took your information down. I say, and an attorney should call you. In the event that the attorney does not call you, the next court date, we'll get one on the spot for you. That's why we waited and got Mr. Johnson in here. That was it. Now, as it relates to the ticket, I see your point. I can't really, it says distribute marijuana for remuneration or commercial purposes without license. That is what the statute that they said that you violated. Then it says defendant was at above location conducting narcotics transaction for U.S. currency without a license. That's what it says. It's not very written, the penmanship is terrible, but that's what it says. So that's what you're here for.
I understand that part.
All right, so I don't need to know any about the case. Now, what do you want to do? Do you want Mr. Johnson to help you, or are you gonna hire your own lawyer?
I don't know how serious this charge is, Your Honor. All I'm saying to you is—
all right, let's go over that. Let's go over that. It's a misdemeanor. is punishable by 93 days in jail and or $500 in fines. That's the maximum possible penalty. If you pled guilty to this as charged, I would fine you $240. I don't know whether the city attorney would give you a delayed sentence or not. This, in my eyes, would be dismissed upon payment. But you have to get the whole offer from the city. That's what Mr. Johnson is here to help you with.
Okay, I understand that, Your Honor. You said without going into any specifics of the case, the whole case is about them confiscating my money.
Judge,
it's not about me selling marijuana.
All right, well, go talk to Mr. Johnson.
Judge.
Or go get your own lawyer.
Yeah, that's what I would suggest, Your Honor. It just seems the conversation, how it goes.
All right, I'll give you some time to get your own lawyer, sir. How long is it going to take you?
I don't know.
That's not good enough.
You saying you'll give?
It's not good enough. You got it. I'm trying to give you some time to get a lawyer, and by you telling me you don't know doesn't help.
Right here, we're witnessing textbook Dunning-Kruger effect, a cognitive bias, where people with limited knowledge overestimate their competence. Psychologist David Dunning described this perfectly. Those who know the least are often the most confident. Gibson believes he understands the law better than a seasoned attorney, despite having zero legal training. From a legal standpoint, this violates Michigan Court Rule 6.005D, which allows self-representation but warns that defendants waive critical protections when they reject counsel. Gibson doesn't realize that every word he speaks can be used against him, and without an attorney filtering his statements, he's building the prosecution's case for them. This is self-sabotage, disguised as independence.
You have to make a decision. I see your dilemma is you just feel that you feel that you shouldn't be here. Maybe you shouldn't. I don't know, because I don't know what happened out there. But it doesn't work like that from my perspective. I got the ticket in front of me and you have to deal with it.
Okay, well, I'll proceed with the situation, man. I don't even need an attorney, because if you just telling me I just got to pay $200, if that's the case, they already took $800 from me for no reason. I ain't sold no weed.
There you go. That's why I got Mr. Johnson in here for you.
He don't seem like he want to represent me. So if you could get somebody else, that's fine, man. It doesn't work like that either. I don't know how it works, Your Honor. I don't know how it works.
Your Honor, and I apologize. Mr. Gibson, no, it's not that. I just think, Mr. Gibson, if you let Attorney Johnson work for you, he's going to request information about the case. Then he's going to discuss it with you. And then the two of you will be able to have a discussion together so that you can figure out the best course of action to resolve your case. That's what both Mr. Johnson and the judge are trying to tell you. If you let him see what evidence they have or don't have, he can have a more fruitful discussion with you. He can't have that full discussion with you today because he doesn't have everything. He's just trying to get it. You got to give him that.
No, Mr. Gibson wants me to say case dismissed and order him to give him his $800 back and let him go on about his business. That's what Mr. Gibson wants.
I definitely agree with that. I'm just letting him know it doesn't work that way. There's a process, and you got to let the process happen. And I think you got Mr. Johnson. I don't think you even realize what you have. So if I were you, my advice to you as an attorney, I would let Mr. Johnson, Attorney Johnson, work on my behalf. That's just my advice, but I have no stake in this, and I apologize.
What do, Mr. Gibson?
I'll proceed.
Say it again?
I said I'll proceed with the railroad. I'll go with it, man. Whatever you say, I'll go with it. I'm not bucking the system.
I'm not saying you're bucking the system or trying to. That's not what we're saying.
Oh, what do I have to do?
You do it, you have to make a decision whether you want to go with Mr. Johnson, whether you want to hire your own lawyer, whether you want to plead guilty, whatever you want to do. It's your decision. You're driving that bus.
I'll go with Mr. Johnson. I just had the only
All
problem.
right, go back in the breakout room and reacquaint yourself with Mr. Johnson and listen first to what he's got to say. And then ask questions. Join the room, please. Let's pass the matter. All right, let's go back on the record with Mr. Jerome Gibson. Mr. Gibson, I've given you an opportunity to speak to counsel. Counsel, what does your client want to do?
Judge, I had to decline at this point. You know, as far as moving
Just
forward,
can't work it out.
can't move forward in a conversation. No, Your Honor.
This moment reveals cognitive dissonance. Gibson holds two contradictory beliefs. This charge isn't serious, and they took $800 from me unlawfully. Psychologist Leon Festinger explained that when facts threaten our worldview, we reject reality instead of adjusting our beliefs. Gibson's refusal to accept the severity stems from his perception that not being arrested means the charge doesn't matter. Legally, under Michigan Penal Code 333.27965, distributing marijuana without a license is a misdemeanor with mandatory penalties. Arrest is irrelevant. Judge Perkins tries explaining this, but Gibson's pride blocks comprehension. He's not listening to logic, he's defending his ego. And in court, ego is your worst enemy.
If Mr. Gibson, I'm gonna tell you this, to be honest with you. Mr. Johnson, he's an excellent A1 lawyer. Is one of the tops in the state of Michigan. I don't know what you're gonna do, but I understand that despite Mr. Johnson's reputation, you do have to have a lawyer that you can communicate with. So that is the most important thing. And if you can't communicate with them and vice versa, then it doesn't matter how good he is. But the way it works is you don't have your pick to a lawyer from this court. We can't just keep bringing in lawyers until you get your one. You got to go hire your own lawyer.
Can I represent myself?
Of course you can, but you need to know the ins and outs of it.
The discovery package, that's what you're referring to?
Well, you can get the discovery. You have to talk to Ms. Snyder and get her your email address, and they have to provide you with that. But okay. You're making more out of it. You're making more out of it than what it is right now. But I mean, I know
I'm not making more out of it, Your Honor. What I'm doing.
No, I shouldn't say that. I shouldn't say that you're making more out of it. I'm saying that by you representing yourself, I don't know how you think you're going to get further, advance this. But go ahead.
Judge, I appreciate you very much. May I be excused?
You may.
Okay, thank you.
Your Honor.
Right.
Your Honor.
I'm
not trying to waste the court's time or anything.
I don't think
like
you are.
that.
I don't think you are.
Why would I have a purpose for doing that? I'm not trying to waste your time.
I said I don't think you are. I said I don't think you are.
I'm sorry.
No, I don't think you are.
You know, this is my second time.
Go ahead.
I can't hear you.
No, go ahead.
This is my second time coming to court on this matter. And the first time I wasn't given an attorney. Okay, this time I was. And me and him don't see eye to eye. I don't know what went wrong. I'm sorry. I'm not trying to waste the court's time. But the first thing that I didn't agree with him was the fact that he told me that this is a serious misdemeanor offense.
Here's where Gibson's strategy collapses completely. He claims he wants to represent himself because I just have to pay $200, but he's catastrophically misunderstanding the process. Pro se representation, self-representation, is protected under Ferretta v. California, but courts must ensure defendants understand the risks. Gibson has no discovery, no understanding of evidentiary rules, and no trial strategy. Psychologically, this reflects illusory superiority, the belief that we're better than average at tasks we've never performed. Dr. Dunning-Kruger found that incompetent individuals fail to recognize their own incompetence. Gibson thinks hiring a lawyer means kissing his butt, when in reality, collaboration is how every successful defense works. He's trading professional expertise for wounded pride, and that trade will cost him dearly.
Wait, let's stop right there. And I'm only gonna spend a few more minutes on this. Why would you agree that this is a serious misdemeanor offense? Why couldn't you agree on that?
Because I wasn't even arrested, Your Honor. First and foremost.
All right, so stop. Just because you weren't arrested, your logic, you're not using some good logic here. Just because you were not arrested does not mean that it's not serious. Is 93 days in jail or $500 in fine serious to you?
Yes, sir.
Okay, so that's what the maximum possible penalty is. This is what he's trying to, does your record mean anything to you?
Yes.
So any misdemeanor should be serious.
Okay.
So you're going off of your logic. I don't understand your logic is not that serious. He's a lawyer. He believes that any one of his clients that's charged with a misdemeanor is serious. And that's what you should want a lawyer that's looking at it like that way. Instead of somebody that's willing to say, hey, just plead him out and we'll dismiss it later, and it'll be dismissed later when he pays the fine.
Right, I agree. But I'm not about to kiss his butt for him to represent me.
The fact that you turn that lawyer down because he's saying that this is a serious matter, you're the one that's coming in here saying that they took my $800. That wasn't serious?
Yes, yes.
So the only basis that you have that is not serious is because they didn't take you to jail.
No, that's not the only thing, Your Honor.
All right.
It's not it.
Are you getting a better understanding of what's going on now? Does that change your idea about what Mr. Basil Johnson said?
Yes, sir. But at the same time, I don't think I got to kiss his butt for him to represent me either.
Oh, man. Oh, come on, Mr. Gibson.
I mean, that's what it seems like.
I'm done. What do you want to do? I'm going to set a trial date. You go ahead and figure it out. Set a trial date for August the 14th. August the 14th. You want to represent yourself. Figure it out. You got the court rules. Come down. You can get a copy of the court rules. You learn them, and you can go ahead and represent yourself. Have a great day. Come back at 9 a.m. on August the 14th. Best of luck to you.
Judge Perkins makes the only decision he can: schedule a trial and let Gibson face the consequences of his choice. This isn't cruelty, it's judicial responsibility. By rejecting Basil Johnson, Gibson lost access to pretrial negotiations, plea deals, and evidentiary suppression motions, all tools that could have reduced or dismissed his charge. Instead, he'll walk into trial without understanding hearsay rules, cross-examination, or burden of proof standards. The prosecutor will have a field day. Statistically, pro se defendants lose over 90% of cases compared to represented defendants. Gibson's $800 complaint will seem insignificant when he's facing jail time and a permanent criminal record. Pride didn't protect him, it destroyed his defense. This case is a masterclass in what not to do when facing criminal charges. If this case shocked you, hit subscribe. We break down the wildest courtroom moments with legal and psychological breakdowns you won't find anywhere else. Don't miss the next one. See you later in another video. This is Court Every Day, the best channel of the psychological and judicial analysis.